While we are waiting, I realize that these are two different cases, but the issues are, the critical issues, substantially the same, is the same, correct?
I did read the briefs in the other case. I think that this case might be a far more far-reaching case than the other case.
Why?
But they still relate to issues about whether or
Isn't
not
the
there's
sole
review.
issue whether there's a right of some judicial review? That's the issue, isn't it? In both
That's certainly the
cases?
issue in this case.
And in the other case?
I believe so.
Well, I think what we're going to do is collapse the arguments in that case. There's really no reason to have essentially an hour of argument when the same issue is the same. So this is what I would propose to do. First, we will have you argue, and then Mr. Walsh. Who we got here? Ms. Bailey? You're responding to both, right? I'm going to ask, tell me how you pronounce your name.
Larzalier?
Larzalier, to argue, and then Mr. Walsh. Mr. Walsh, okay. And
there is a slight difference between the two cases.
that's okay. There is a slight difference, but we can actually follow the arguments. Okay, so, and you'll get enough time. So, why don't you proceed with your case, Ms. Larzalier? You can call the second case, yeah.
May it please the court, my name is Cara Larzalier, and I represent the plaintiff appellant, Janice Indeck, and with me today is my partner, Owen Gallagher. The real question for the court today is whether or not the Client Security Board has unlimited discretion in granting or denying claims for reimbursement.
Well, that's what the rule says.
The
Yes.
rule does not say that they have unlimited discretion.
The rule says what it's unappealable. Their decisions are unappealable.
There's
And
our
so-
brief cites multiple cases where even though there are provisions in a statute or elsewhere that provides that there is no review, that does not alter the availability of actions in the nature of certiorari. So we argue here that there is still an action available in the nature of certiorari. The purpose of that is to allow review when there is no other adequate, reasonable remedy. Now, there's no doubt that the Client Security Board itself brought this rule amendment to the court as a result of the Rusi case, which was the only reported decision that I know of that sought an appeal of a Client Security Board decision. And in the Rusi case, the court did find that the Client Security Board had made an error of law. And I believe that as a result of that case, the Client Security Board requested this amendment from the court. However, today is an opportunity for this court to review and determine and interpret what that statement means, whether or not it precludes actions in the nature of certiorari.
Well, first of all, it's our rule, correct?
Yes.
And second of all, it was published for comment, so it's not as if this was done in the dark of night. I mean, everybody knew what was happening here, correct? So
I believe that we actually did ask for the comments on this, and no one was able to provide us with any comments, so I'm not sure.
well, that doesn't mean
Because there weren't any.
I'm not sure how well vetted out this issue was.
Well, it
I
was.
know
It
that
was-
this court,
It was published in in Lawyers Weekly, various places, and there were no comments. So it was thoroughly vetted out,
there were no comments.
as far as I know.
well, or even if there were, the issue is not whether there were or there weren't comments. The question is, was this change made without anybody knowing about the change? We publish rules for comment, and then we get comments. If there are no comments, we take into account that there are no comments. If there are comments in favor, we take that into account, and if there are comments against, we take that into account. But the point is that we don't proceed without somebody drawing to our attention. You don't realize what you're doing over here.
I understand.
But I
This
can
case,
tell
I
you
think-
for a fact there were no comments.
Okay. This case, though, I think presents issues that may cause the court to reconsider the application of that rule or to interpret that rule to allow actions in the nature of certiorari. The question really is whether or not this court wants to allow the client security board to have unlimited discretion. The SJC rules also provide that reimbursements are a matter of grace and not a right. This does not mean that the board has limitless discretion. That interpretation of the rule would be inconsistent with the purposes and guidelines under which the client security fund was created. The fund is a public trust, and the trustees that are appointed by this court are charged with dispersing the funds in accordance with the trust's purposes and its terms. In the Superior Court rules, it does not provide for unlimited discretion. It says that the board must make decisions,
Are you
for example,
claiming there was a breach of fiduciary duty here?
by the board.
By the trust? By the trustees who had the obligation to carry out the purposes of the trust?
Well, what we argue here is that they did not conform their decision. They did not make a reasonable, fair decision that was consistent with their prior principles, which is what Rule 4.05 says that they must do. They must attempt in the public interest to establish fair, reasonable, and consistent principles for the allowance and rejection of claims.
Well,
we argue that they did not do that in this case.
If, as I think the record shows, this was their principle, as I understood it, was that they don't consider interest, so that they saw the payments that were made as being return of principal, right? That PAL as opposed to PLE. In
Yes,
this instance.
that's what they argued. But in this case, the claimant, Janice Indeck, she entrusted to the attorney, Morris Goldings, her entire life savings for safekeeping. And she did that back in 1982.
Right.
He was her lawyer on a variety of matters. Over the course of those 18 years, he paid out to her the dividends that were earned on the principal, $569,000 that she had entrusted to him. The board says that essentially that they don't recognize loss of interest, and therefore the monies that she got back over time must have been a return of principal, and therefore she has no compensable claim. But then is the board also saying that, for instance, suppose that the Attorney Goldings, the arrangement had been that Attorney Goldings would roll over the interest in the account instead of paying them out on a monthly and quarterly basis as he had done, and that then at the end of a period of 18 years, that Attorney Goldings had taken all the interest for himself and absconded with the interest and left the principal in the bank account. Is the board still saying in that case that the attorney is not...
The board has to act very flexibly, and also with, particularly in the Goldings case, with regard to hundreds of other applications. So if this woman gets relief, they're all going to be coming in wanting relief, because there were all kinds of equitable adjustments made.
I think this is a very different claim than the other claims, and it's my understanding that although the board must always be ready for instance, another enormous claim like this. This was the largest defalcation in the United States history. Morris Goldings had taken $17 million. Of course, they must always be ready for another claim like this, but it was my understanding that availability of funds were not an issue.
Yeah, but well, go ahead.
Well, I was just that as I looked at the annual report of the Client Security Board for this year, they still have $10 million of unpaid claims relating to Mr. Goldings. So
they have those in, I believe those, if I understand the report, they have those in reserve. The reason that they have those in their reserves is because their position is that they do not want to pay out those claims until the bankruptcy proceeding, which involves Mahoney Hawks, the law firm where Morris Goldings worked, until the bankruptcy has paid out their full amount of claims. That way the board will know exactly how much each claimant has received from the bankruptcy, and they would make up the difference for the amount that they've determined they are entitled to. And therefore that they're holding those monies. The bankruptcy proceeding has been pending now for 6 years.
The board's been reimbursed on the $150,000 they gave her by reason of subrogation. Do you say that's error too?
Excuse me?
Are you saying that's wrong too? That they shouldn't have claimed by subrogation?
Well, essentially they haven't given her anything. because essentially what they've given her is a short-term loan without interest, because they gave her the $150,000, but as soon as she received her first distribution from the bankruptcy court, they expected repayment of
Because she signed a subrogation agreement.
That's correct.
Did she have counsel at the time?
She did have counsel at the time. Because part of the problem with the board's process is that it's very opaque. There was no decision at the time when she was awarded the $150,000. Although she did have of course, she had the subrogation agreement, which was written. It was unclear at the time that they had denied her claim, and that really what they had given her, the reason they had given her the $150,000 was under provision of the board rules that says that even where there is no compensable claim as they see it, if they feel that a person has dire circumstances and hardship, they can make an award, and that is what the $150,000
Hardship.
was, a hardship.
Your claim here isn't that the board, you started by saying the board didn't follow its principles. It followed its principles. You just don't agree with those principles. Isn't that it?
Well, the principles are that the reasoning must be fair and reasonable and consistent with prior decisions. There are other cases that were before the board where, for instance, they did pay out interest. And so this is not consistent with their other decisions. Our other point is essentially that this is not interest, for instance, like you would receive in a court case where if you had been, he defalcated with her money back in December of 2000. She did not get a decision on the board from the board until August of 2002. She's certainly not asking for any interest from the time of the defalcation until the time of her award. What she's asking for is the principal. She received the interest. They just viewed the interest as a return of principal. Her principal was still with Morris Goldings of $569,000. As of December of 2000, he stole that principal. So she lost the principal.
Is your claim, I take it, it's that when the court tries to, is it that the court needs to ascertain what was the court's intent when it passed this amendment to the rule, that is, adding this, there shall be no judicial review? You're not claiming as of right that as a constitutional right that you have a right of judicial review, are you? It's really how we should interpret our own rule.
Yes, I think it's how the court should, whether the court should interpret that rule to either bar or permit actions in the nature of certiorari or otherwise as the court may see fit.
I take it, at least from the Attorney General, who takes the position that we don't review it, but then does address the particulars of the claim, that some of the dispute, is how you characterize it, but the board was essentially looking at the $569,000 that she gave to Goldings, and that she received from that $912,000, correct? That's the amount that she received over time, and that that the board was not, and that's why I'm saying here, the Attorney General is taking the position that it acted within its discretion, and I was asking you whether there was some sort of breach of fiduciary duty, that was such an unreasonable position to take, that giving her the advancing her the $150,000 out of the hardship provision is so out of line that anything that a trustee could do is that's really the basis of your claim, correct?
Well, that's the basis of our claim that we brought before the board. We sought a reconsideration of their decision. The bankruptcy court has determined that Mrs. Indeck has lost principal of $569,000. When we got that decision from the bankruptcy court trustee,
Right.
which it accepted her claim, and it specifically excludes the bankruptcy claim allowance, specifically excludes any interest or attorney's fees of any of the parties that were in the bankruptcy, because they determined that it would be easier to divide up the funds by just taking the principal that everyone was lost. So there has been a finding already by the bankruptcy court that she has lost principal. That's when we brought on her behalf request for reconsideration of the board's decision with, attaching, of course, for them all the information with regard to the findings of the bankruptcy court. And so it is our position that it is unfair and unreasonable. There may be, reasonable minds may be able to differ possibly on these issues, but all we're asking for is the opportunity for review. If you don't have the opportunity for review, material errors of law, discriminatory, arbitrary decisions can happen. And it's the public's perception, whether those happen or not. If there's no review, there is the perception that there could be discriminatory or arbitrary decisions, incorrect decisions. There's a decision by the board that was made just in this June of 2006, also relating to Morris Goldings, where the claimant had brought a claim for a personal loan that he had made to Attorney Goldings so that he could purchase a condominium in Florida. There was not an attorney-client, although he had been his attorney in the past, there was no attorney-client relationship with regard to this personal loan. It was a debtor-creditor relationship, and the board is charged only with reimbursing defalcations from clients by their attorneys. Here, the board reimbursed this claimant for monies that they lost for a personal loan. So by requiring some sort of review, you're able to keep the board on track with its charge, despite their best
We'll be inundated with these things, inundated.
This rule was only this rule that prevented that claims to prevent judicial review was just passed, was just amended in 2002. In the 30-year history of the board prior to 2002, the only reported decision where somebody's appealed a board decision was the Rusi case. That's the only one. Other than the two that you see before you today, I don't know of any other reportable decisions. So I don't think that is a concern, that there's suddenly going to be an onslaught of appeals.
Thank you.
Thank you.
Ms. Lazare. Mr. Walsh, why don't we have you go, and then Ms. Bailey, you will have time to respond to both.
Good morning, Your Honors. Michael Walsh, and I represent myself, and I represent my client, Dr. Josette Audoire. And I would distinguish my case from the one that was just presented in two major factors. One is our claim in Worcester Superior Court was not disputing or contesting or seeking review of a board's decision to either grant or deny reimbursement. Secondly, we are not seeking an interest in any portion of the client security fund. The funds that we are seeking an interest in are from malpractice proceeds that were administered by a settlement trust that was Attorney Christopher Panos from the firm of Craig and McCauley. They were set up to try to distribute in proportion to the many victims of Shirley Hoke the limited malpractice insurance proceeds. I'm sure the board's familiar, the court is familiar with Shirley Hoke, which prior to this hearing I thought had the greatest defalcation case, but apparently not. My client lost her retirement to Shirley Hoke. Shirley Hoke induced my client to sell real estate in 1998, took other funds from my client, and then promised high-yield investments, just a variety of scams and false people and bogus promissory notes and things like that. The settlement trust, one of the caveats for me in representing my client was that the settlement trust was going to review this case not on law or equity, but based upon the insurance policy. We had already filed a case in Worcester Superior Court against Shirley Hoke and the law firm that she worked for. And I came to an impasse with my client and saying, they're not going to judge your case. You're going to have to dismiss your case with prejudice in Worcester Superior Court, put yourself wholly at the mercy of a single arbitrator with really no practical right of review. And there's a huge exclusion in this policy of acts beyond the scope of employment. And largely, a lot of what Shirley Hoke did was arguably beyond the scope of her employment. So I could see us giving in on our case in Worcester, going to the settlement trust, and then them saying, sorry, it's beyond the scope of employment. So we came to an impasse.
But they did allow the entire claim, didn't they, the trust?
They did not. They allowed $200,000 or so of a claim of $250,000. without rationale, without explanation. And of course, my client was desperate. She had gone into retirement. She had to come back out of retirement because of this defalcation of funds. And so she was glad to receive what she did receive. She received from the settlement trust $50,000, from which I deducted my contingent fee. The board, she then makes application to the board, and they take the $200,000 or so that the settlement trust had determined was her allowed claim under the terms of the insurance policy, and they say, that's your universe of being made whole, is this $200,000. And then they say, you will need to assign to us any future disbursements from the settlement trust, and we will pay you $146,000 or so. And they did pay that. Now, they did that. I was representing her, and they obtained that settlement trust without my participation. My signature doesn't appear on it. I was...
Well, but she sent something into the board saying she was not represented.
Right. We did have an impasse, but we then reaffirmed our agreement.
Would you agree that if we rule in the prior case that there are no rights of review against the board's decision, that this case goes down?
No, I don't
also?
agree, Your Honor.
Why not?
Because we are not arguing against a decision to either grant or deny reimbursement. We are arguing in a plea in equity that the assignment isn't valid and that Josette Audoire had already assigned to me as her attorney those portions of the settlement proceeds that came from malpractice insurance, which I had a right to. So she could not assign what she didn't own. It's like a tenant in common in real estate. You can only convey to someone else your interest. She only had a percentage interest in any funds that would come out of that insurance proceeds. Now, I had a percentage interest.
But, Mr. Watt, let me see if I understand this. I thought the trust says you're entitled to recover $200,000, if that's what it was, or
Yes.
203 or whatever it was. Then the board says that's going to take a while. We'll pay you quicker, right?
Yes.
But you need to assign whatever we pay you. You need to assign when you ultimately get it from the trust, right?
Right.
Okay. You still could recover your fee because what she is going to get from the trust is more than the board paid her, isn't it?
No.
Oh, because of the $50,000 that was
Yeah.
already paid?
The board paid $50,000, and then there would be a subsequent distribution. Once they cleared up all the dust settled from people who maybe needed to make claims but hadn't made claims, once the dust settled, they were going to make a subsequent distribution. And it's this subsequent distribution that the board received an assignment from my client. And it's an unknown quantity. I find that to be questionable right there, that you're going to ask someone to assign something that we don't know how much it is. How is that fair in saying...
Well, the board certainly is not going to be able to collect more on its assignment than it
what it
extended
paid
to
out.
her.
I would not think so. You're right.
Yeah.
However, the issue of being represented, it was, I wrote to the board, I communicated with the board pending their decision. I didn't really see an investigation happening. No one asked me to come in to argue. I don't know that there was ever any hearing. It was simply that it seemed like the board delegated to the settlement trust its investigatory responsibility, that we're going to take this $203,000, although my client claimed $250,000 and established we supported that claim. We're going to take the settlement trust number and say that's what's going to make you whole. And I just find that that's a third-party decision that the board should not have incorporated. And also about communicating with my client directly. I think the board...
So in that sense, you are challenging the board's decision with respect to a distribution. You're saying the board should have found more than $203,000. In other words, the board should have declared that she lost more than $203,000 because of a defalcation.
I question it. I state that mostly in rebuttal because I don't get to reserve time. I think my sister's going to say something about that. So I state that mainly in rebuttal.
Okay.
And I think I've fairly stated my case if there's any more questions.
Thank you, Mr. Walsh.
Thank you.
Ms. Bailey?
May it please the Court, my name is Christine Bailey, and I'm an Assistant Attorney General appearing on behalf of the Client Security Board in both matters. In terms of distinguishing these two cases, if it's not already clear to the panel, what the difference is that in the Indeck matter, Indeck is challenging this court's or any court's ability to review the board's decision. In the Audoire Walsh matter, they're trying to collaterally attack that by saying the challenge doesn't go to the board's decision-making authority, although I note Justice Cordy's point, but rather they're challenging the assignment and subrogation agreement. We would maintain that the assignment and subrogation agreement was a condition of their decision to reimburse. So if this court were to rule in the Indeck matter that the board's decisions are not subject to judicial review, then the Walsh case would go away because there would not be any subject matter jurisdiction to review the assignment and subrogation agreement, which was a condition of that decision.
It's surely the case that someone can sue the board for violation of a contract, or, I mean, can't someone sue the board for securing an assignment under duress and coercion or something? I mean,
well, we would acknowledge that that perhaps the courts could exercise their equitable authority to entertain a claim against the board. But here, in these two cases, are matters squarely within the board's discretion. That is, the decision on whether to reimburse a claimant, and a condition of that reimbursement that was the assignment and subrogation agreement that was at issue in the Dr. Audoire and Walsh matter.
That's, I think, the nub of the issue. I think when one of these things are filed, we've got to take a peek at the underlying dispute between the parties. And if it's one that essentially challenges the board's discretion, we should say, if this is the way we vote, you have no authority to do that. No judicial review. If it's one that alleges something egregious, such as my brother just suggested, duress, coercion, taking advantage of, those kinds of egregious things, then perhaps we might intervene more as a matter of superintendence of the board than as a matter of appeal from the board's rules.
Yeah, yes, Your Honor. And I would also make an important note here as an important matter. This court retains its rulemaking authority over the board. So this, as my sister at the bar suggests that the board acts with unfettered discretion, that's far from the truth. Under the SJC rules, the board is required at least on an annual basis to provide a report to this court. And this court could exercise... Excuse me?
Which it does.
It does, Your Honor. And it could require...
Over the court meets with members of the board, I think, consistently since I've been on the court once a year, and discusses with the board, what its activities are, what it's doing, based either questions arising out of the report or any other questions that the court has.
Yes, Your Honor, that's true. And in addition, the board has retained broad rulemaking authority over the board. In other words, the court could modify the board's rules, amend them. The court could even dissolve the board if it felt it was necessary.
I have a very basic question, and it doesn't affect the decision, but why is her claim considered a non-compensable one? Is it because it's a claim for principal?
Yes, Your Honor.
Talking about Indeck?
Indeck.
Okay.
We're talking about the Indeck matter. The board, let me just step back on the Indeck claim for a moment and just point out a couple of things. Indeck and Attorney Goldings they had an oral agreement. There was also not a lot of documentation concerning their transactions that survived. Whether it existed in the first place, it's not clear, but not a lot survived. So the board took basically on its face Indeck's claim that she had given Attorney Goldings $569,000 and that he returned to her over the course of the relationship tax-free on more than $912,000.
Why was it tax-free?
Attorney Goldings apparently told her that it was tax-free and that she did not have to claim it.
So it was not income?
It was not she did not consider it to be income.
Well, it was income. It just wasn't taxable income. I mean, it could have been from some kind of municipal bonds or something like that.
It's unclear.
But it's income.
It was income, but it's unclear how Attorney Goldings was handling her money or how it was generating interest, but he had told her it was tax-free. So over the course of their relationship, she recovered nearly twice the amount that she gave him. The board accepted that, did not challenge that. And the board applied its general principle that it considered that to be the interest she recouped to be a return on her principal investment, and so that there was no compensable claim.
Return of, I mean,
A return of principal plus
A return
interest.
of, not on. Okay. Well,
Yeah,
that's a big
so
difference.
at the end of the day.
So you consider it as a return of a principal of $519,000 and an extra $400,000 interest, essentially?
Yes, Your Honor.
Okay. Okay.
And therefore, because she had no compensable claim, they looked at the hardship provision, which allows them to basically make an award because of out of hardship considerations. In this instance, they gave her an extra $150,000. I would also like to point out another important distinction between the Indeck cases and the Indeck and the Audoire and Walsh case. In the Indeck matter, this Indeck is seeking a certiorari review from this court, and I would like to emphasize that the elements of certiorari review are not were not present in this the proceeding, or could not be fairly characterized the proceeding before the board. The board's hearing could not be fairly characterized as being judicial or quasi-judicial in character. This is one of the essential elements for certiorari review. While what constitutes judicial and quasi-judicial is not perfectly clear, there is case law like the School Committee of Boston case and the appeals court decision in Pronghorn, which is 13 Mass App Court 70, where some of the characteristics are discussed. Here, the board's hearing was not preceded by any specific charges. In addition, the board's written decision was not accompanied by any formal findings of fact. In addition, as Justice Graney had pointed out before, the board is looking at an individual claim, but is not looking at that claim in isolation. In other words, the board must take into consideration matters of general applicability. That claim in relation to the other claims that are before the board, and also the viability of the fund. And this is all in the SJC's rules that govern the board, and also in the board's rules itself. So,
Ms. Bailey, just one question. Do you have your brief in front of you in the Indeck case?
I do, Your Honor.
Okay. Could you just turn to page 31? Because this is, you said something at oral argument which seems a little inconsistent. I want to make sure that I understand what you're saying here. Okay. If you go down, you with me on page 31?
In the Indeck brief, you're meaning the board's brief in the Indeck matter?
Yes.
Yes.
Okay.
That's yours, the red brief.
Go ahead.
Page 31. Halfway begin down, it says, you get to the 569 and then the 912, and then it says, the board acted within its discretion in considering the 912,600 received from Golding as a return. It should be of her principal, isn't it? Not on.
I think that's
That's why I asked the question that I did. I was
Well,
confused by that.
Yes, Your Honor. I think that's more of a fair characterization. In other words, she wasn't entitled to anymore because the principal was returned to her plus interest in the tax-free 912.
Okay, so but that can't be on, because otherwise there's an assumption in that sentence that all of the principal still is that she never got any of her principal.
Yes, Your Honor. I think it was not as clearly written as it perhaps should have been.
But on is not clear. Anyway, so you're saying the 912,610 was returning to Indeck principal plus interest.
Exactly, Your Honor. And this is a principle that the board has followed in other instances.
Can I ask you a question? There was some suggestion made that the award in the Indeck case did not, and I only have the briefs here, I don't see it in the briefs attachment, whatever notification she got as to her award, it didn't clearly indicate that it was in essence rejected, the claim was rejected, but the $150,000 was under a hardship principle.
Yes.
Is that correct? What did the
well,
notification or decision say?
If you look at on page 99 of the appendix, basically it indicates that they inform her that they held a meeting and that they considered her claim. This was after the hearing at which Indeck was present by phone and her counsel was also at the hearing in person, that they decided to make an award to her of $150,000. I think what happened after that initial decision is that there were discussions between Indeck's counsel and the board in which it became clear to Indeck's counsel that the board did not consider her to have a compensable claim and awarded her under their hardship
So
provision.
that was not in the, that was not in the letter or the formal decision that was provided to her?
Yes, Your Honor, that's
It's
correct.
communicated to, there's something in here that suggests it was communicated, however,
It was,
to counsel.
I don't think there's any disagreement amongst the parties that it was ultimately communicated to counsel. I would also note, though, that letter and the lack of formal findings is one of the reasons why the board's proceedings could not be fairly characterized as judicial or quasi-judicial. In other words, there's not any formal findings of fact. In addition, an essential element of certiorari review that she had a right is also missing. The third element that must be proven is that Indeck suffered a substantial injury or injustice arising from the board's decision to grant her the $150,000. Implicit in that requirement and also explicitly in the statute concerning certiorari review is that there must be a right at stake. And as the board's rules explicitly provide, the SJC rules, specifically 405, all determinations are a matter of grace and not of right. So she does not have the basic elements here for certiorari review.
Ms. Bailey, let me ask you this, because we've collapsed the arguments. The claim about no judicial review is clearly applicable to both. The claim that, could you address the claim of Mr. Audoire, Ms. Audoire and Mr. Walsh about why,
Certainly.
that doesn't survive judicial review here?
Certainly, Your Honor. The appellants in that case are trying to circumvent, I think they are conceding that there's no judicial review of the board's decision on reimbursement. They're trying to attack that collaterally by saying what's at issue here is the assignment and subrogation agreement that Dr. Audoire entered into with the board. However, it's explicitly provided in the Client Security Board Rules 8 and SJC Rule 405, Section 4, is that as a condition of their decision to reimburse, the board can enter into these types of agreements. So if this court were to decide that there is no judicial review, then that should flow to the review of the assignment and subrogation agreement as well.
And there's nothing illegal about this agreement, is there?
No, Your Honor. There are no set of facts and no allegations in the complaint that would support the assertion that the board acted improperly in entering into this agreement.
Well, this is another one of these, it seems to me, you take a peek, and if you take a peek at the assignment and subrogation and it's not unlawful or void as against public policy or any other such egregious kind of thing, then it's within the board's discretion and it's barred under the judicial review principle.
Yes, Your Honor. There's no, I might just point out that the mere allegation of that this agreement was coercive or was an adhesion contract doesn't rise to the level of adequate appellate argument.
I understood the gist of the argument, namely, if under our rule you make it as a condition, I mean, I don't think that Mr. Walsh was arguing facts other than the very fact that in order to get your claim considered, you're going to have to sign this agreement is in and of itself coercive.
Well, Your Honor,
I'm not saying it is. I think that's the gist of the argument. It's not that somebody from the board went out and had a, side conversation with Mr. Walsh and said, we usually don't do this, but in this case we're worried or anything like that.
Well,
it's
if
standard
that
operating
argument
procedure.
is valid, then all practically all the board's proceedings would have to grind to a halt, because routinely, I think if they give out money, they get these subrogation agreements, if there's something out there to subrogate against.
Yes. Under the board's rule, they are required, and let me just make an important point, they only are recovering the amount that they put out. In this particular case, the board was, in Dr. Audoire's case, the board wasn't making any kind of threat in order to gain some advantage. Rather, they were saying to Dr. Audoire, we're going to give you the same amount that you would get from the settlement trust. We're just going to give it to you faster. In other words, she was put in a better position, a condition of which was entering into this agreement. She was not, in addition, she raised no objections to the assignment and subrogation agreement. She was treated no differently than any other claimant before the board that was also involved in the settlement trust. And the board was acting consistently with its public policy of getting money into the hands of clients who have suffered losses based on dishonest conduct by members of the bar. They put her in the same position she would have been had she stayed with the settlement trust, got her basically gave her the money faster. So there's really no set of facts here that would support the claim that this was in any way coercive or an adhesion contract.
Attorney Lazalaire, if I understood her correctly, was saying that in other cases the board has awarded interest, or has paid interest to people, but they didn't do it in this case, and at least for purposes of public perception, there appears to be an unequal treatment. What do you say about that?
Well, there's one case that Attorney Lazalaire cites to where, quite frankly, it's a little unclear as to whether that relationship was a attorney-client relationship or a debtor, there was a loan, more of a loan going on. In that circumstance, in addition, there wasn't this payout. It's my understanding that there wasn't this payout at interest over time in the same way that there was in the facts involving Indeck's case.
I take it in any event. Really, what the client security board addresses is where a lawyer is acting as an attorney. Implicit in the board's decision with respect to Mr. Goldings is that all that he was doing was acting as an attorney. That issue is not before us because nobody has raised it. It is a very interesting question, as if we had judicial review, whether we would agree with the board that they owe anything to any of Mr. Golding's, quote, clients for essentially acting as an investment advisor, banker, whatever it is. So that isn't here.
Yes, Your Honor, I would completely agree with that, the parties agree that Indeck was a client of Attorney Goldings.
No, I understand, but if you want to open it up for judicial review, you might have to open it up for judicial review. The fact that the board decides that somebody's acting as an attorney, if you want to open it up for judicial review, maybe the court won't agree that he was acting as an attorney.
The money would have to be returned.
So that may not be here, but I just point out that there are real problems with,
From both ends.
picking only a piece of what gets opened. I mean, where we have other situations where there's clearly judicial review, we look at the whole situation. Is there anything else that you need to raise with us, Ms. Bailey?
If the court has no further questions, I rest.
Thank you.